All rise. Fourth District Court of Appeal, First District is now in session. All those who cause to plead all night in attention shall be heard. To God save these United States, the great state of Florida, and so forth.
Be seated. Good afternoon, ladies and gentlemen. We'll go ahead and call the cases in the order that they appear on the docket. There's only two now. There were more. But what we would like to do, even though there's only two, is we'll break for coffee after the first case and invite all of you to come and have coffee with us. So with that, we'll call the case of Burke versus the state of Florida.
May it please the Court. I'm Wendy LaQuasto. I'm of Fox and LaQuasto. I'm here today representing George Burke, a criminal defendant charged with, convicted of aggravated battery and sentenced to 20 years. I would like to reserve 4 minutes for rebuttal. There were 6 issues that were raised in the briefs in this case. Because my time is limited in the appeal, I would like to focus on just 3 of those. 2 of the issues, issues 2 and 3, pertaining to the fairness of the trial, and the third issue I'd like to address is the sentencing issue that is designated as issue 4, concerning the 20-year mandatory minimum. I'm not waiving my any of the other 3 issues. I'll just rely on the arguments that are in the briefs because of the limited time. I am, of course, happy to answer any questions that you have on those 3 other issues. And the second issue in the briefs was contended that the trial court deprived Burke of due process right to a fair trial by precluding him from mentioning his theory that post-traumatic stress induced him to confront the truck driver until after he testified in his case in chief, thereby depriving him of the opportunity to have the jury hear the evidence in the context of his defense.
Did the trial counsel object when the trial court imposed the limitation on the opening statement?
He did not. I don't see that as a preservation problem, though. I think you have to look at that in the context. I know that that's what the state has argued. I think you have to look at this in the context of how this issue came about. Defense counsel was fighting to have the doctor's testimony admitted and the post-traumatic stress evidence presented, and it came up as a discussion on a motion in limine to exclude it. And while defense counsel was successful in having the evidence presented, it was done with a restriction that he couldn't mention it in opening statement. And the judge repeatedly said this. I've cited page 29, 79, 88. This judge was really adamant about the fact that counsel would not be able to mention this in opening argument. And I think you have to think about what a trial attorney's job is. You won the day, but how much are you going to push the issue and maybe make the trial judge mad, angry with you.
Isn't that always the issue with preservation?
Well, it is, and it's always the issue for you all. You all think it's easy, but I know that when I talk to trial attorneys, they don't think that it's so easy. But I will say this ruling about not being able to mention this in opening argument was, that condition was clearly part of the judge's ruling. And so I think that the purpose of preservation is to bring the issues to the trial court's attention. I don't think that anybody could say that this restriction to opening statement wasn't an issue that was clearly before the court. So I don't see that there's a preservation problem here.
What's the purpose of opening statement?
What is the purpose?
It's not evidence, right?
It's not evidence.
And it's just to help the jury understand the evidence as they hear it.
To indicate what you think what you believe the evidence will be, what evidence will be brought forward, and to allow them to understand, to inform the jury what the theory is, so that they can understand the evidence as it's presented in connection with your theory.
Don't trial judges, though, frequently, especially something that realistically, as a defense, means that your client would have to basically admit a lot of the allegations that the state was making, but say, yes, but let me explain why those things happened. And so your client obviously wasn't obligated to do that. He could have sat and did nothing at all during the case. And so what would be the trial judge's remedy in case of it never was brought forward for the jury to consider.
Well, I think the Spaziano case answers that question. I mean, this is not an automatic mistrial if Mr. Burke doesn't take the stand. There's a curative instruction that could have been given. The opening isn't evidence. That could have been repeated. There could have also been statements made by the state attorney during its argument that to the effect of, defense counsel said they were going to present this and they didn't, so where's the evidence? And, it could have been corrected in that way. This is not an automatic mistrial case. The cases cited by the state in their brief, Hayes, involved a state attorney who in opening statement said, I'm going to present evidence that the defendant confessed to the crime and then didn't present that evidence, and they held that mistrial was appropriate there. But here, there's other alternatives, and Spaziano points that out, that this is just not an automatic mistrial in this situation. And I think you really have to think about Mr. Burke's defense, too. He confronted this driver because of his post-traumatic and his sense of hyper-alertness to danger, and that propelled him to the confrontation.
Is that the only time a trial judge can exclude something from opening statement is when it would result in a mistrial if the evidence didn't come out? In other words, is it your argument that the only time a trial judge can limit opening statement is when the failure to produce that evidence at trial would necessarily result in a mistrial? Is that the...
That's not my argument. My argument here is that this trial judge in this instance said, I'm going to limit your opening argument because if he doesn't testify, this will be a mistrial. And that argument, that theory is just wrong under Spaziano case. That, maybe a judge could limit opening argument in some other case. That's not before me, and I can't answer that question. But the reason he gave here for this limitation is mistrial. He clearly said if Mr. Burke doesn't get up here and testify, then all this post-traumatic stress can't come in, and then I'm going to have to give a mistrial, and I'm not going to have a mistrial. And that's a wrong reason. And so that's really where the error is in this case, is the trial judge improperly limited the opening argument based upon an erroneous reason.
So if he didn't explain why it would be okay, it wouldn't be error? If he just said, no, counsel, I think you ought to wait until the evidence is actually presented and I don't want you to mention it during opening statement, would that have been okay?
So you're saying if he hadn't said anything about mistrial?
If he didn't add, it would have resulted in a mistrial. I mean, is that what made it error, because he was afraid that it might result in a mistrial?
Well, those aren't the facts that we have before us. The facts are that he said it would be mistrial, and that's what I'm maintaining, is that reason is wrong.
Well, don't you have to have the defendant take the stand to complain post-traumatic syndrome, and then you want to make sure perhaps that the defendant was actually going to testify before that came in? Isn't that one of the...
Well, that's one of the conditions in Mizell that they said in order to make this admissible, then the defendant does have to testify. But if you look at this case, there's no way that Mr. Burke could not have testified in this case. Otherwise, you're dealing with a victim who says, he walked up to me and said, you're full of shit and shot me. And unless Mr. Burke was willing to take the stand and to explain his side of the story and what propelled him to the confrontation, I mean, state attorney said this was a crazy situation. I mean, he needed to explain it. So a fear that Mr. Burke, I understand that defense counsel is never going to actually decide until after the state's rests its case whether the defendant is going to testify. But I mean, everything in this case pointed to the fact that if Mr. Burke didn't tell his story, then this is going to be really open and shut. And he really needed to do that. And this is, to me, just not a legitimate fear and could have been solved in some other way. Unless you have some other questions on that, I know I need to move on to my second issue, which is the issue number 3, and that's a special instruction based on the Williams case. The evidence of self-defense while approaching the truck driver did not negate the defense that the shooting was accidental, and the requested alteration or limited instruction on self-defense and justifiable use of force. It's well established that the defendant has the right to have the jury instructed on his defense. Here, Mr. Burke's defense was that post-traumatic stress syndrome propelled him into a confrontation with this driver. He, rather than fleeing or stopping, he was under this sense of hyper danger that caused him to confront this driver, and because he feared for his life, he brought his gun. His defense was then that the gun accidentally discharged. He never contended that he shot Mr. Porto in self-defense. He never contended that at all. He always maintained it was an accidental discharge of the gun. So Mr. Burke requested a special instruction based on Head Note 3 in the Williams case, which is a very factually similar case where
Counsel, I've read the Williams case, and I'm not sure that it didn't seem that case dealt with a hybrid type instruction that you're seeking here.
Well, as the state pointed out, that what they were requesting in the Williams case was a self-defense instruction that was not allowed in. It was, and so in that aspect, Williams isn't, the instruction that was requested is not the same. What Burke is requesting is a special instruction based on the Williams case, because this is an unusual case in which there's a self-defense, justifiable use of force that propels him to the incident, but then when the incident is occurring, there's an accidental shooting. And so he requested an instruction based on that footnote to explain that to the jury, that we're not saying, and we don't want to suggest, that Mr. Burke shot this man in self-defense. That's never been his case. And they just wanted to make it clear to the jury that you could consider these two theories and that they were not inconsistent. And that's what the instruction requested. And in terms of the altered self-defense instruction, I quoted that instruction on pages 36 and 37 of my brief, and it's a really long instruction, and when you look at it, and in terms of what Mr. Burke's defense is, the length of this instruction and the detail of this instruction, which is what defense counsel wanted to keep out, really bring you to the point of that Mr. Burke, to lead the jury to believe that Mr. Burke did shoot this man in self-defense or in justifiable use of force, and that was just never his theory. So we maintain that it was confusing to the jury. My third point
on the sentencing issue, would you briefly address the supplemental authority? I know you don't have a lot of time, and the preservation argument.
Sure. That's what I'm here for. The supplemental authority is, my point on issue 4 is that there's no finding that there was a discharge of a gun to warrant the 20-year minimum mandatory. This is not a question of, and I think maybe the supplemental authority might have gone to issue 5 in terms of whether the trial court has discretion to do a mitigation. And on that issue, my point is that this judge felt that he didn't have any discretion. So it's not a question of we're appealing the fact that he didn't get a downward departure. We're appealing the fact that this judge erroneously felt that he didn't have any discretion. And that's issue 5. On issue 4, my argument is that there was no finding by the jury on the verdict that he discharged the firearm, so the 20-year mandatory minimum is wrong. On the preservation point, defense argued before that 10 years was based on the possession. And as to the argument on the verdict form that the state has raised, they said, well, he should have objected to the verdict form. Well, really, the verdict form says possession, and that's really to Mr. Burke's benefit, that the only issue the state presented to the jury for the jury to decide was whether he possessed a firearm. The state neglected to put the issue of discharge or great bodily harm to the jury on the verdict form, and to require Mr. Burke to object to that would be requiring him to object to something that would be highly prejudicial to his case. The Amos case, the second part of the ruling in the Amos case goes to the fact of a special instruction that's not submitted to the jury, and I say that that's on point. I'm into my rebuttal time. Thank you.
May it please the Court, Counsel. Christine Gard on behalf of the State of Florida, and I wanted to apologize in advance to the Court for my late notice of appearance. However, we had emergency arise in the office on rather short notice. So with that, I'll move straight to issue 2, as appellant has raised. The problem is this issue has never been preserved for review. There was no objection, and he waived any complaint by just not reserving his opening argument, which was his remedy. If he had proffered that the defendant was definitely going to testify at that point in time, he could have reserved and presented his defense at that point in time, and that is really the remedy that's available to him in this case. But just because the judge said that he was afraid it was going to result in a mistrial, the trial court, of course, can be right for the wrong reasons, and it could very well have resulted in a mistrial in this case. We just don't know because that's not what was permitted to happen. And at any rate, the whole issue, it's harmless because, number one, an opening statement isn't evidence, and number two, defense counsel was permitted to argue that in closing argument and able to present the evidence once he met the Mizell test.
Did you find any case law on just what are the consequences of an erroneous ruling of prohibiting opening statement?
Well, I think it has to be a fairly, I think the only case that's cited by counsel involved is Arizona versus Washington, which is certainly not the grounds that were argued below.
Did you find anything applicable?
I did not. So that
I'm just thinking back from studying opening statements. The Chicago jury studies showed that a pretty big majority of jurors make up their mind by the end of closing statement. But of course, I know that's statistics, we can't do it, but opening statement, I'm sorry. Opening statement is a pretty big tool in an advocate's toolbox, so to speak. And until I read that report, I used to waive opening statement, as did most lawyers over in my area. And then that started happening. Now here we are having a judge, I think, commit an error by not allowing the opening statement. And I'm just sitting there flipping around in my head just how harmful is that? And is it a harmless error because he got it in later and got to argue it or what? So.
Well, again, opening statements are simply not evidence. The evidence has to be developed throughout the trial. And in this particular case, the Mizell test specifically says the defendant must testify to lay that predicate. Had perhaps some facts different than this case happened and there was a guarantee that the defendant was going to testify early on, his testimony had been proffered, something along those lines, then perhaps the trial judge would have erred. But here, the defense's real remedy was to waive opening and reserve opening statement until the time they presented their case. And as a former trial attorney, I did that in a number of cases where I wasn't able to know exactly what my witnesses might do or say when they approach the court, and sometimes that's the better measure to make sure you get before the jury exactly what it is that's going to be produced. And in this case, the state would have potentially been greatly prejudiced had the testimony been lengthy, had the opening statement been lengthy, focused on what the doctor was going to say on PTSD and what the defendant was going to say about his PTSD condition. The testimony could have been significant enough to result in, or not the testimony, the opening statement could have been significant enough to result in a mistrial because all of that information would have been for the jury without it actually being in evidence. As to issue 3, failure to instruct on the accident issue, first of all, it's not preserved and it's been waived. There was never a written instruction presented to the trial court. It is not contained in the record on appeal. It is not orally contained in the record on appeal. And in fact, defense counsel says, on one occasion, we're not asking for a special instruction to tell the jury that it was an accident, and defense counsel stated he could not craft an instruction that wasn't misleading. And the court couldn't come up with its own that wasn't misleading. And the result of that is that it can't be error to have instructed the jury in essentially what would have been a misleading way. And again, the facts in Williams are not analogous to the facts here. In Williams, you have a gentleman jump into a fight between two individuals to protect one of the individuals. The aggravated battery occurs when the defendant falls upon one of the combatants. And the result of that is that the box cutter or knife or whatever it was in that case actually plunges into the victim at that point in time. That's not what happened here. Here we have a defendant who's decided that he is going to take the law into his own hands and that it was his constitutional right to pull this truck over because he believed it was swerving within the lanes, although he admitted in his testimony that the truck could have been simply swaying from the weight of the load and the size of the load. He pulls him over, he approaches the car, and he shoots him. He doesn't fall back when he was behind the truck for some period of time. He doesn't call Star FHP. He doesn't call 911 to report it. And he doesn't call law enforcement afterward either. He just allows the victim, but for, the grace of an officer who was off duty driving by, to report the incident. As to issue 4.
Is accident even in defense? I mean, realistically, what we have is a lack of intent, right?
Right.
I mean, and jury was instructed on intent.
Correct.
And basically what the defense is, I didn't have the requisite intent because it was an accident.
I didn't cock the gun all the way back. I didn't pull the trigger. It had happened accidentally. I didn't intend to shoot the victim, but the evidence is clearly to the contrary in this case. The state's firearms expert testified that there's a special safety device on this, a blocking mechanism that comes up when you cock the trigger, when you cock the gun, requiring the trigger to be pulled. He spun the cylinder before he
I'm saying, the defense is normally, I did it, but.
Right.
I did it, but I was insane. I have an insanity defense. I did it, but it was necessary. Yes, I did commit the crime, but I have a necessity, and let me explain my necessity. Or, yes, I shot him, but it was in self-defense. It wasn't, I didn't commit the crime and now instruct the jury as to my particular argument. I mean, is there a difference between a legal defense that someone's entitled to a jury instruction on and basically their theory of why one of the elements isn't established?
I think in this case, that's what it amounts to in this case, is that their argument was the state didn't prove its case. The state didn't prove the intent element. So their argument really was the state didn't prove that he intended to shoot the victim, which is a necessary requirement to convict. You don't need a special instruction to accomplish that. You simply argue, as the court's instructed you, you must find or will instruct you, intent must be proven. Here, there's just no intent. Here's what happened. Here's our theory of the case. There was not a special instruction required to do that. Under the facts of this case, there certainly may be cases where you need a special instruction. I'm not sure that his defense was as clear as we'd like to believe.
The case law that requires the judge to give an instruction on the defendant's theory of defense, does that mean a legal defense, or does that include any argument the defendant may have as to why one of the elements isn't established or more than one of the elements isn't established?
Well, that same case law requires that they actually produce the instruction, which was not done here. But I think that what they're talking about in that case law, and certainly where that case law tends to come from, is I haven't seen a case where it comes down to the factual scenario presented here. In general, those cases are cases that involve a legal defense. Self-defense is a really good example of that, or insanity is another really good example, where the defendant is entitled to that instruction because it's just not there otherwise. Insanity doesn't exist in the standard jury instruction on aggravated battery. I mean, there's no way to get your defense across but that way. Otherwise, we would have to have, an instruction every time the state did not prove that serious bodily injury occurred in this case. The defense has alleged that serious bodily injury didn't occur in this case, and you have to have a special instruction on every element of every crime if that was the defendant's theory. So that's not what the state would assert those cases are aimed at. We would assert that they're aimed at actual defenses that are, your normal kind of admission/excuse defenses, or, any of the, you did it, but it was in self-defense, so this plea and avoidance kind of defenses. And there may be other defenses that I'm just not thinking of right now. As to issue 4, any error is harmless. The court, now under the current case law, is supposed to look at whether or not a jury could have found beyond a reasonable, or any reasonable jury would have found beyond a reasonable doubt.
Discuss the case primarily relied upon by the appellant, the Santana case. You didn't do that in your answer brief.
The Santana case, if I can have a moment, Your Honor. In Santana, it's just to the contrary of Amos. One court reached the conclusion that because there hadn't been a specific finding of discharge nor was there any reference to the information or the charging document, there couldn't be an inference made based upon the second count of the information, which was shooting or throwing, I think, a deadly missile. And the court reasoned there that as a result, the most that could be inferred from the verdict form was that he possessed the weapon when he committed the aggravated battery. In Amos, they didn't have a special interrogatory on serious bodily injury, great bodily harm, and they felt like the information and verdict were silent, but they found that the discharge was inherent in the offense that was charged.
Was that the case here?
Here, I believe the
Charged with possession, right?
No, there was a special interrogatory finding that he possessed the firearm, which is one of the normal special interrogatories. But I believe, without going to the record, that the verdict form found him to be, I would hate to say it, but I think it was guilty as charged. I haven't looked at the verdict form since early this morning. And the other thing is that the state has cited some case law that indicates those facts need to be in dispute before you need the verdict finding. I believe we cited the, I don't know how to say it, but the Peritti case, the Perritte case, which is out of the 5th District, I believe. And in that case, they hadn't had, I think it was a capital sexual battery case, but they didn't have an age finding as to the perpetrator, as to the defendant. And the court there found that because that element hadn't been disputed, there was no error in imposing the capital battery sentence, essentially, a capital sexual battery sentence. Here, something similar happened, that he never disputed that the firearm had been discharged. It was his theory was that I accidentally discharged the firearm, which the jury rejected. So there was never a dispute that the discharge had occurred. And the state attorney, I think, was generous in resolving the 25-year mandatory minimum when they were before the trial court and admitting error on that when perhaps he or she didn't have to. But in this case, because the element wasn't disputed and because all of the evidence shows that the discharge happened,
well, defense
it's
counsel
harmless.
mentioned several times in their closing argument that, in fact, the gun was fired. I mean,
Yes.
Not only do they not dispute it, they concede it. I mean,
Correct. So not have the discharge, I mean, Apprentice to deal with cases where the element's disputed or you're enhancing a sentence based on something that can't be found inherent in the verdict. Here, he's found guilty of aggravated battery, by discharge of the firearm, I think is how the information charged it. He was indeed found guilty as charged, I'm sorry. And he could be convicted in both ways, great bodily harm or that. So because of the lack of dispute and the way the information charged it, it definitely fits Amos rather than Santana. And unless the court has any further questions, the state will rely on its brief for the rest of its arguments.
On issue number 2, I just want to say that the state attorney's suggestion that the remedy was to reserve opening statement to the beginning of the defense's case is not a remedy in this situation because it doesn't fix the fact that the jury would have heard all the evidence without the filter of any indication of what Mr. Burke's actual defense was. I understand some attorneys have waived opening argument, but as Judge Browning said, he never did it, and I've read a lot of trial transcripts over the years, and rarely do I see an attorney waive opening argument and present it only at the beginning of their case. As for the Mizell case isn't about opening argument, so I don't think there's anything in there that would preclude a judge or would require a judge to limit opening argument. On the second issue, The state has alleged that the jury instruction isn't in the record. It's an issue that's not preserved. It wasn't written. It wasn't orally. And as I explained in my reply brief, clearly the judge and the state attorney had possession of a written document with this instruction, and they both referred to it. Yes, it's not in the record. And as I said in the reply brief, if this court finds that the absence of that instruction is a detriment to your ruling, or that you cannot rule on this issue without that document, then I would submit that you should give Mr. Burke an opportunity to supplement the record with that instruction, because it does, in fact, exist. As to the fact that there was contrary evidence about Mr. Burke's intent it doesn't negate the fact that he's entitled to a jury instruction on his defense, and accident is a legal defense. And I see that I'm out of time, so unless you have any other questions, I will just simply ask you to reverse and remand for new trial in this case. Thank you.
Thank you. The court will take recess, and we invite everyone to come have coffee with us in the common.